I'm Andy Agathangelo, the founder of the Transparency Task Force. The Transparency Task Force is now a well-established organisation campaigning for consumer interests in relation to the financial services sector. To be very frank with you and very blunt with you, when I started the Transparency Task Force back in 2015, I really did think that the Financial Conduct Authority was a big part of the solution to the many issues that I could see happening within the financial sector. Issues where, putting it bluntly, consumers were in some way being shortchanged. However, to my surprise and disappointment, it's fair to say that bit by bit, I've started to see the Financial Conduct Authority in particular as a big part of the problem. And some of my thinking is heavily influenced by the evidence I've seen about people who have interacted with the FCA and found themselves not being treated right, not being treated fairly. And that's a theme that carries on time and time again in all kinds of different situations. And as you are all aware, we're here today gathering to listen to an update from Ned Beale and Simon Bishop from the law firm Housefeld, who are acting for the APPG, the All-Party Parliamentary Group on Fairer Business Banking in relation to the matter of the APPG versus the Financial Conduct Authority. Even now, months and years into this, I still have to stop and think that what we've actually got on our hands here right now is a situation where our elected representatives are politicians who are part of the all-party parliamentary group, had to make a decision some time ago to challenge our primary conduct regulator over its unwillingness to do what I and so many others would simply see as the right thing, to stand up for the interests of those who have been in some way the victim of malpractice, malfeasance, misconduct and mis-selling by banks, particularly in relation to aspects of the interest rate hedging product scandal. Even now, it is genuinely shocking to think that our elected representatives are having to take our regulator to court to try to make it do the right thing. I'm sure you would have seen, ladies and gentlemen, in the narrative that we've circulated about this judicial review, that we really do challenge the FCA as being morally bankrupt. Morally bankrupt. They're not doing the right thing. That, to my mind, is self-evident. But as we've all learned as campaigners over the years, this is not the sort of battle that you can win in the court of public opinion. It's a battle that you need to win in the court, the actual court. We're talking here, of course, about what amounts to lawfare. Lawfare, the art of using legislation to convince the other party that they're wrong, or perhaps more appropriately, to convince a judge that the other party is wrong. Ned Beale and Simon Bishop are two individuals I and many others have grown to like and respect and be very, very grateful for. They are going well beyond the normal limits of capability in terms of acting for a client on, significantly below market terms to do the right thing. And what we have tonight, ladies and gentlemen, and I'm really looking forward to it, is a chance to hear from the legal professionals about what the current state of play is, about the battle lines that are being drawn in this good versus evil. It's as simple as that. This good versus evil challenge in the courts that's going to be played out next year and perhaps later. Can I please invite everybody to very, very warmly welcome Ned and Simon, acting on behalf of the APPG on Fair Business Banking, welcome them and make them feel very much at home. Guys, we think you're superstars doing what you're doing, and we're very, very grateful for it. We're going to do all we can as TTF to back and support your efforts. We believe in what you're doing. We believe in what you are, and we believe in this fight. And just one final point for me before I pass over to Ned and Simon. In the event that this particular battle is won, the shock waves it would cause throughout all the work that the Transparency Task Force is involved in would be absolutely monumental. This is the fight that if we can win this, it's going to be significant beyond words could describe. Thank you very much, gents. Ned and Simon, over to you. Thank you.
Thanks very much, Andy. And thanks everybody for joining. It's great to see so many people. And of course, it's great to have Heather Buchanan and Jackie Roberts of our clients here too. I thought I'd just really briefly set the scene. And I will do that briefly because I know lots of people here know lots about this case already. And then give you just a couple of thoughts on the FCA's defence and our reply and where we are. And I'll then hand over to Simon, who will have his own thoughts and might also touch on disclosure, because that's, I think, the next phase of the legal fight. So just very briefly, it feels like this case has already been going on for quite a long time. We are seeking a judicial review of the FCA's decision in late 2021 not to take any action in response to its own lessons learned report by John Swift KC, which severely criticised the FSA for imposing a sophistication test that excluded a third of victims from receiving redress for IRHP mis-selling. So under the judicial review rules, you've got 3 months to commence a claim. And me, Simon, Heather, Jackie, Kevin Holland-Rake, who was then chair of the APPG, very shortly after we saw Swift's report and the FCA's response published pretty much the same day, saying we're not doing anything, decided we should bring a judicial review. So we began it. We had an initial exchange of submissions. We then had a long and frustrating wait while we waited for a court hearing for permission. And we then had the permission hearing in front of Mr. Justice Fordham just before the summer break, which was a full day in calls. And that permission is the first hurdle you have to get through to get a judicial review to trial. And actually, a lot of judicial reviews fall at that hurdle because it's quite a high one. So I think only 1 and 2 get through. Anyhow, we got through, and I know some people on the call were in court, and that was great. And I think we really were fortified seeing how Mr. Justice Fordham reacted to our arguments. So this autumn, the FCA served their defence, and we have just served our reply. And that means, on the face of it, pleadings have closed, and we can go through to a full trial sometime in 2024. Having said that, we still think the FCA has not provided adequate disclosure, and there may well be a disclosure phase before we get to a final hearing. So in terms of where we are right now, the FCA's defence was very interesting in some ways because it did give quite a lot of detail about the FCA's decision-making in 2021. And the defence is now public. The FCA originally refused to let us publicise it, but we got permission. They have continued to refuse to let us disclose the 3 witness statements they relied upon in support of the defence. And I really don't understand why those can't be public too, because it's public servants taking a decision that affects the public. But anyway, that's where we are. But that was interesting. And we did get quite a lot of detail about the decision making. I must say my personal impression was that when you read the way people were looking at this within the FCA, they only were ever going to make one decision, and that was not to do anything. And you can kind of see that fixed viewpoint throughout. And that fed through to some quite important decisions the FCA made. So, for example, the FCA asked Mr. Swift to water down his conclusions, and indeed he did. And the FCA confirmed that they put pressure on the reviewer to reduce the level of criticism. Secondly, the FCA took a conscious decision not to consult in relation to the decision. And they say, well, we didn't need to do that because we knew that people would be unhappy about it. And I have to say, for me, that is just absolutely, it is a contradiction in terms. If you know that people are going to be unhappy, then there should be more of a reason to consult, not less. So they therefore had a deliberate plan to release the decision, to release the report and their decision on the same day, which cut out any possibility of consultation or influence on that. As some people in this group know, there was this whole slightly weird episode where the FCA didn't reflect the decision in its board minutes, and then they altered the board minutes after we had sued them to put the decision in, and that was all very strange. So irrationality is one of the grounds for judicial review, and I think and irrationality and procedural unfairness. And I think that whole narrative sets us up quite nicely for the trial, because I don't think the FCA have done their job of making a rational, structured decision. And indeed, one of the findings of John Swift was that the FSA failed to consult consumers properly back in 2012. And that's one of the findings the FCA actually say that they adopt in their response to the review, but they certainly didn't adopt it in relation to the decision itself. So that was what I saw the key points coming out of the 2021 decision. There obviously are 2 points to this, because the second half of it is looking back at 2012, and that the decision to impose a sophistication test on the terms in which it was imposed and in the way it was reached in the first place. And I think I've probably been talking enough, so what I might do is hand over to Simon at this point to talk about that aspect of the defence and reply.
Thanks very much, Ned. Just to echo what Ned said there, it's great to see you all, and for us to have the opportunity to update on the case and where we are. As Ned said, we are challenging a decision of the FCA that took place in 2021, but it is in many ways intrinsically linked to the actions of the FSA in 2012, and in particular its decision to adopt the sophistication test, thereby excluding huge volumes of transactions and ultimately people from the compensation scheme that was set up. The FCA has made some attempts to effectively bar our claim on the basis that actually what we're really trying to do is challenge that 2012 decision, and the challenge there being that we are way too late to be doing that. Interestingly, this was a point raised at the permission stage, and a point that was considered by Mr. Justice Fordham when considering whether or not we should have permission. And it was roundly rejected by him, and in concrete enough terms that we think that we can now say the FCA has no right to be making that argument because the court has already determined it. So we're pretty confident that that basis of the FCA's defence will fall away. That does not mean, however, that we don't need to know the truth of what happened at that time. It's obviously, as I say, intrinsically linked to how the FCA came to hold the view that it does now, that the imposition of that test was rational, and therefore in 2021 it was rational to disagree with Swift and take no action in terms of arranging compensation. The next really big piece of work that we have to do, as Ned alluded to, is to pick up the fight on disclosure. Generally, in judicial review proceedings, the government authority that is a defendant to them has an obligation to discharge what's called a duty of candour. So it effectively has to litigate on the basis of all of its cards being face up on the table. They are the custodians of all of the information relevant to this decision, and they therefore have a duty to explain to the court and to the applicant all of the evidence and the bases for making that decision. Notwithstanding that duty, it has been something of a fight already trying to get the FCA to give over documents. They have an obligation to do so before the proceedings are issued, and they did in a very, very restricted way with us, such that we had to make repeated requests and have ended up being engaged in piecemeal chains of correspondence trying to get them to comply with that duty. So it's a time-consuming and challenging process. The duty of candour expands somewhat when you get past permission. And so we have received further disclosure from the FCA in the context of it giving its defence. As Ned said, and as I said last time we met, there are some questions as to confidentiality in some of those documents such that we are not able to make them public. But what we can say, and some of this is contained in our reply, which is now a public document, is that we still consider the FCA to be in breach of its duty of candour, and we consider them to have failed to respond to our disclosure requests adequately or sufficiently. So what does that mean? Well, it means that we will almost certainly be making a disclosure application. This is where we apply to the court for directions that the FCA give proper disclosure, and we have particular categories of documents and information that we are seeking. I won't go into all of them, not least because some of them potentially touch on the confidential issues, but one that's perhaps of particular interest relates to how the sophistication test came to be, and in particular, the Treasury's involvement in that. We have evidence in the Swift report itself that Treasury was concerned about the overall level of compensation that would need to be given by banks in the course of this process. And they indicated that their view was that that level needed to be reduced. And obviously one way of effectively doing that would be to cut out a big portion of those transactions and those bank customers who would ultimately otherwise would ultimately qualify for the scheme. Given that finding in the Swift review and the responses of the FCA to date on the suggestion that Treasury influenced their decision, which by the way would be completely improper and very supportive of a case that the decision was not lawful. The manner in which they have responded to that has enabled us to plead, so allege, albeit by inference, that Treasury did exert influence on the FCA, and that the FCA introduced the sophistication test in part on the instruction of Treasury. And obviously, if that's right, and we will need to corroborate that if we are to persuade the court that that's what happened, and that's in part why we will be looking to get disclosure on it. But if that's right, there's a very troubling conflict of interest at the heart of this decision, because Treasury obviously was the custodian of the taxpayers' financial stake in RBS and Lloyds, who were big, heavily exposed to the bill of interest rate swap mis-selling. So that's a particularly interesting part, and we will be seeking further disclosure in respect of that, along with other categories. So we're going to have to go through that process. It's going to be, we imagine, heavily contested, which will mean that there will be exchanges of arguments in writing, there will be exchanges of evidence to support the application, and ultimately we hope there will be a hearing. So there's lots of work to do on that, but we feel that we've got the categories of information well scoped. When you make these applications, you have to be very targeted, specific. You have to know what you're asking for, and you have to be able to explain why it's relevant to the proceedings, and we think we're at that stage. And we also, as I say, have a strong basis to infer certain things about the way the FCA has conducted all of this. So we're in a good place on that, but obviously, in many ways, the work just begins on that, and we hope that the application will be issued shortly. And when it's heard, obviously, it will be a public hearing, and that will be an important milestone in the case. So, I mean, I'm sure through the TTF we can keep everybody updated on that, but just I think that's the most important next event, all with a view to preparing for a trial of this case at some point next year. So I'll stop there. I think that's probably enough of an update. I don't know. Obviously, Ned and I are both happy to take questions on any of that.
Simon, Ned, thank you very much indeed. I'm sure everybody else is going to want to join me in once again thanking the guys for the work that they're doing. It's very, very much appreciated. Very, very much appreciated. A few elementary questions from myself, Simon and Ned. You may or may not have answers to any of this. In terms of timescales, what's your gut feel in terms of how things may pan out timings wise? You know, at what stage do you think we might get to the next point and thereafter? Any rough feel on that?
The sequence will be application for disclosure. That will need to be exchanges will need to be had on that, and then that will need to be heard. That may result in changes to the scope of the claim, so we may need to amend pleadings as a result of that, or we may not. But I think we would do well to get that application heard by the end of February. And I would hope to have a trial in April or May, but that's subject to court's diaries and how that application might go. But that's instinctively how I would answer that. I don't know if Ned has any different views.
And you're talking April, May 2024, yeah?
24 next year, yeah.
Fantastic. And next sort of elementary question, if I may. I've heard some, I haven't yet personally read your response to what the FCA sent back, but two chaps whose opinions I rate very highly have said it was absolutely superb. Could you tell us a bit more about what was in that response? And perhaps if it is public knowledge, can you pop a link to it in the chat or enable me to do so?
Yes, in terms of accessing it, it will shortly be live as a link on our crowd justice page. Right. So obviously we have the fundraising page for the costs in this matter, and there's all the case information on that page. And a request was sent over earlier today to get a link to the document on there, which will mean it's there for everybody to see. I don't think it's gone up yet, but we can share it with this group once it has.
Thank you very much indeed. Could you tell us what's in it? I mean, what are the key points in it? What are the highlights within that document?
It's quite hard to distill into sort of digestible points, but ultimately the purpose of a reply is to close off the scope of the dispute. So we've made allegations. The defendant has come back and said we disagree for these reasons. And then in the reply, you respond to that disagreement, and hopefully by then you know what the parties do and don't agree on. The defence contained, in many ways, a kind of doubling down on their defence as it was articulated before the permission hearing. And we obviously had the helpful permission judgment in order to respond very forcefully to some of those arguments. So, for example, they had argued that it was an abusive process to be trying to litigate a decision that took place in 2012, 2013. The judge said that that's clearly not what we're trying to do. And they, notwithstanding that judgment, they came back and argued it again, and that's enabled us to argue very forcefully that they're on very weak ground in relation to that. There are also some issues, for example, in relation to the contractual documents that gave rise to the scheme, and in particular the FCA arguing that the banks had a contractual right, if you like, to expect that entering into those contracts was in full and final settlement of any regulatory exposure that they may have. And the defence has made that argument again, and we have again some very strong points to go back on that in respect of. So there's lots of moving parts in it, but broadly speaking, the sequence of events has enabled us to issue a good, firm reply.
So it's largely legal arguments, although we do have a witness statement given by Mike Lloyd, who is on the call, Because one of the things that the judge said at the commission hearing was, well, look, can I have an example of who are these excluded customers? And fortunately for us, unfortunately for him, Mike is a very good example of a customer who was unequivocally excluded and didn't get justice then or through the BBS. So actually, Mike gave a statement just explaining here is one business that has never got redress for this obvious mis-selling.
Ned, Simon, thank you very much. In just a moment, I'm going to share my screen and talk about the very important crowdfunding page. And perhaps, Mike, if you're up for it, after I've covered off that kind of territory, Mike Lloyd, if you want to, perhaps you give everybody a brief summary of what your case is about. I think that could be very, very important, because we aren't just talking about abstract things here. We're talking about real people with real lives and real businesses that have been absolutely damaged, no other word for it, as a consequence of what's actually happened.
I certainly try.
Thank you very much. It'll be in about 2 or 3 minutes. So I'm going to share my screen, and I'm going to take everybody to, frankly, a really important page. If we think of the JR as a vehicle, the vehicle, of course, needs fuel to operate. It can't go anywhere without that fuel. But believe me when I tell you that the finances of TTF are pretty damn precarious. Despite that, I'm going to be putting £100 into this myself. If everybody did a bit, make your own mind up about what the right amount for you is. It might be £100, it might be £1,000, it might be £10,000. My suggestion would be, make your own mind about the amount, but make it a certainty that you do something to help. Everybody can do something. Everybody can do something. I think Ned and Simon will explain in a minute that the 12 days to go bit is actually nothing to be concerned about. Obviously, when it gets to my banking details, I won't put that on the screen, but let me just sort of show you the process here. So you click on the amount you pledge, £100, and believe me, for me, it's £100, but I'm very, very, very happy to do this. I can think of nothing that would make me happier than one day next year, let's say, reading an email from somebody or a text message from somebody or a WhatsApp message saying the guys have won, but the APPG has actually defeated the Financial Conduct Authority in relation to this. Keep me updated, yes, please. Continue to payment, which I'll deal with now. I'm not going to put that on the screen for very, very obvious reasons. Can I please ask everybody to make a mental, emotional commitment now that once I put the link into the chat, you do something, whatever is the right amount for you. There's no judgment around what the right amount is, but please, everybody do your bit. We absolutely know, just like last time, that if everybody does their bit, we'll get the funding that we need, we'll get the resource we need. The guys can perform on that stage that we are building for them through the fundraising effort. So please do follow the lead I've just set out and do whatever you choose to be the right amount for you. Meanwhile, can I please invite Mike Lloyd just to explain 2 things really, Mike. First of all, why were you happy to do a witness statement? Tell us about that. And don't hold back, Mike. I mean, you're a very strongly spoken guy. Don't hold back. Why did you want to do that witness statement? And give us, in a nutshell, what was in it. Thank you, Mike.
Well, I wanted to do it, obviously, for hopefully at the end, my own benefit and my ex-co-director's widow's benefit, but not just for us. I want to do it for all of us and prove the point that we were royally shafted by the banks. We're all in this together. It's not just me. There are 5,000 missold companies in my understanding. Like everybody else, it varies greatly. I was, when the sophistication criteria was introduced in January 13, I was absolutely stunned. I was of the belief in the period between the announcement of the mis-selling in June 12 that we were going to get somewhere. We're actually going to get a result. And when it came in January, and we fell foul fell on the basis that my turnover was more than 6.5 million, and my staff numbers were more than 49. I was just absolutely outraged. I had a group of public houses, 23 in total. I can't operate 23 public houses with 49 members of staff. It was some people working for me for 4 hours a week, 8 hours a week, or whatever, and it was just an absolute nonsense, and clearly just designed to eliminate the bigger cases. So I wanted to stand up and be counted, and I'm grateful that Household have actually stepped into the breach here and fought for us all, and I am massively thankful, and I'm hoping that we are going to, at long last, get some sort of compensation. Like everybody else, the interest rate hedge products were enforced on me as a condition of our borrowings. We already had the money. It was just then made. It was a condition in 2006 that I had to enter into them for a minimum of 10 years of 95% of our borrowings. And as far as we were concerned, it was just like an insurance, to protect me against interest rates. The chaps from the bank came to show us this wonderful presentation that showed us historic interest rates, and this was a free position for us to be protected against interest rates. At no stage were we ever told that there was going to be potential colossal liabilities on us if interest rates plummeted. Here's the floor, here's the start. As far as I'm concerned, I'm between these 2 points. So we took out between 2006 and 2009, 5 of these products, apparently to protect us, which, of course, as we all know now, had the exact opposite effect. So when interest rates fell to 0.5%, it cost me £27,000 a month extra interest to pay Barclays as a result of servicing that, which, as you might imagine, caused mayhem. We were really beginning to struggle because we were losing all that cash, and the lady from Barclays was introduced, who was the business recovery specialist. So the first thing she did when she came to see me was use the words, "You represent a, excuse my French, effing risk to us. And as such, I'm going to increase your lending rate by another 1%. So instead of it cost me £27,000 a month, it then moved to £33,500, £34,000 a month. That went on for just over 3 years. So I paid Barclays well in excess of £1 million in extra interest. We had independent business reviews that were called for by Barclays, which cost 50,000 quid each. And of course, I had to pay for those. So instead of helping me, they're screwing me to the floor. Am I bitter? You bet. So we had assets that were worth something in the region of 13.5 million. My borrowings from the banks were 7.5. So over 6 years, it was basically gradually removed from me. The only way for us to get out of the products that were enforced conditions was for me to buy myself out of it. Barclays then, at a meeting when we told them that we couldn't survive if we were continually under this pressure, they told me that they would refinance the business in 2012 to allow me to get out of the products that they put me into, because there were still 4 years left. And I now believe that they deliberately delayed that process until after February 2012, because that way the statute would have disappeared. So we got to the position in May 2012. I had to buy myself out of it, and then I found out that the exit fees were priced in US dollars, which not only put me in a position I'd already been screwed once, I was then in a position I was then keeping my eye on the US dollar rate every day to tried to find the cheapest day for me to get out again. Anyway, Barclays lent me the money on the 29th of May 2012, bought myself out, and that cost me just over £950,000. They charged me a £75,000 arrangement fee. And 4 working days after I bought myself out, they called in the loans. So I was rather bemused and shocked. We did our best to protest. We went to see the bank at Canary Wharf. They just rubbished us. This was after 20 odd years of owning the business. So all in all, it cost me £2 million in extra interest. Lost the company in its entirety. Never got a halfpenny penny back. All the equity went. All the ongoing earnings that we would have had lost. It was astonishing, and I said we then thought when 2 weeks after we were put into administration, the FSA announced the products, specifically the products that had been sold to us, which were Category A toxic products, we would be put back in the position we would have been in had the missale not happened. And then, of course, we got sophistication. And as we all know, the fight's gone on from then. 2 years after being put into administration, 2.5 years after, my ex-colleague Rodney became ill, and I blame the stress that was imposed on him. He was 68 years old and would work for years to build something for our future, and he died in a few days. So, yeah, I'm bitter. I can't really say much more than that. He should still be here, and we should be both having a comfortable position. It's caused massive stress to my personal position. Clearly, at my age, I'm not in a position I've been able to go out and find anything else that pay me anything like I used to earn out of my company. It's meant I've not been able to pay my mortgage properly. I've had to rely on my mother-in-law to help me pay my mortgage and get my kids through their teenage years. It's been a nightmare. All of none of it, in fact, my view, our fault whatsoever. So I really can't say anymore.
Mike, you don't need to say. You really don't need to say any more, Mike. Mike is one of many individuals who have been shafted by the trickery and the chicanery and the dastardly conduct of the banks. But not just the banks. You can almost understand that the banks are commercially minded only entities that will do everything they can to screw every penny out of everybody. You kind of almost expect that. But when we've got a regulator that has a statutory objective to provide an appropriate degree of consumer protection, that our elected representatives have given that FCA that job a budget of, I don't know, is it £300 million a year? All those people doing all those jobs. And not only do they not protect consumers from harm, it seems to me that they take actions and they make decisions that put people like Mike and many, many others directly in the line of jeopardy. This is what we're fighting against. That's why this fight matters. You will, I'm sure, have perhaps seen me or heard me talk about this particular point many times over. For me, ladies and gentlemen, this judicial review against the FCA is about what Robert F. Kennedy was saying back in the 60s when he said, every time we turn our heads the other way, when we see the law flouted, when we tolerate what we know to be wrong, when we close our eyes and ears to the corrupt, I'm going to repeat that word, corrupt. because we are too busy or too frightened. When we fail to speak up and speak out, we strike a blow against freedom and decency and justice. This is far more than just a banking dispute. This is far more than a court case. This is literally an opportunity for me and Mike Lloyd and Andy Candy and Steve Middleton and all the others to stand up rather than stand by and frankly define ourselves. We have an opportunity here, ladies and gentlemen, to decide who we are by supporting this righteous, noble and necessary cause. Can I please invite everybody to put their hands together to show our appreciation to Mike for standing up rather than standing by and using his witness statement as a bit of leverage within the case. Mike, I can see you want to come in. Please do, Mike. And then we'll go to Heather Buchanan. Go on, Mike. Thank you.
Can I just chuck in, obviously I wasn't expecting this. Can I just chuck in a few other things about the, if you like, the deliberate deceit from the banks of where one. In the presentation that I, again, have submitted as part of my statement, the guy who was from Barclays Capital, there's a disclaimer on the documentation to say that the products that they are presenting are for investment professionals only. I'm not an investment professional, never was, as categorized by a certain ruling in the FSM market, that they will only be entered into by such people and with people who have experience in that particular area. Now, clearly, again, I'm not that. They also, in 2008, Barclays sent a document for us to sign, which classified us as a retail client. And in January 2009, our relationship manager signed a documentation to say that we were a retail client, not an eligible counterparty, not a professional, we're a retail client and will always be treated as such, i.e. our turnover level had to be something like 20 million quid and the balance sheet had to be at least 20 million pounds. I can't remember exactly what the situation was, but therefore, in 2009, I'm classified as a retail client. At the time of them selling me these products, I was a private client. And then 7 years retrospectively after selling me the products, I become a sophisticated client. Well, clearly it's just utter bullshit, isn't it?
Yes, it is. There's no other way of looking at it, Mike. It clearly is. We're going to go to Heather Buchanan. Some of you may not know Heather. Heather, please take the opportunity to, first of all, introduce yourself and explain your role in the APPG. Then please do share your thought, Heather. Thank you.
No, thanks very much, Andy. So, yep, Heather Buchanan, Director of Policy for the APPG, and have done so for many years now. So, kind of through the thick of it. I first came to the APPG as an IRHP, victim as well. And whilst I was not deemed sophisticated, was put in an insolvency situation. So we never really were able to, you know how that ends. Never able to get anything back from that. But I'd say, through the process and the experience, one thing that we've all learned along the way is that what's fair is fairness and legality are often two different things. Particularly now that we're working in the within an unregulated area. So just a couple of reflections on the actual permission that we got. And for those that did attend on the day, I mean, I must admit that I went thinking, oh God, we've got an entire day in court talking about procedural stuff, and it's, going to get very technical and dry. And it's pretty much the kind of closest thing I've come to rock and roll in quite a while in terms of the interest and the level of defense that the FCA took. And I think this is a really important point, because they very much focused on this contractual element, as Ned and Simon talked about, which alluded to a contract between the banks and the FSA at the time. And it did raise some serious questions, and raised a serious question with the judge as well. And that, is the FCA saying that it contracted itself out of its own regulatory duties? There was a great emphasis that was placed during the trial as well on the legitimate expectations of the banks. Thought it quite interesting. The regulator never actually discussed, or the regulator's KC never brought up the idea of legitimate expectations of the consumer. They were supposed to be protecting. And the other thing that I found striking, and I think striking just in the very fact that they pursued it as an idea and as a defense, was that the regulator, whilst it acknowledged that it needed to make rational decisions, it didn't necessarily acknowledge that he had to provide evidence for those decisions. And both of those arguments, which were relied on quite heavily, I think did them no favors during the day, but also show a level of arrogance that in terms of where they kind of see accountability, and I guess that for us is a hugely important element. And I'm sure that Ned and Simon, and then I've got one other question for Ned and Simon, if you could, please, because we haven't really talked about this yet. And it was just when Mike was speaking and thought about it. Has been a recent Supreme Court judgment, hasn't there, about basically when you've got hidden charges or undisclosed things, and that the actual effect on limitations. I'd be interested to know if that's any thought in there. So, yes.
Thanks, Heather. Thank you very much, Heather. Let's go to Ned and Simon for any comments and reflections on that.
Do you want to handle the limitation Heather's question, Simon? Heather, you put us on the spot.
Yeah, I don't know the judgment. I think it must be going to the question of when it becomes known to a potential claimant that there has been some kind of dishonesty or fraud or some other kind of deceit, and whether, I think the question in this context would be whether or not there's any similar argument that might be raised in relation to the sale of swaps, and whether or not there are any hidden fees and so on, which
I think Simon might have frozen. I'm going to invite Nigel to come in with his. Sorry, Simon, back to you. I think he froze momentarily there. Carry on, please. Yeah.
Hi, and sorry about that. Can you hear me okay, Andy?
Yes, we can now. Thank you.
Yeah, sorry, I've had slight tricky internet connection. Yes, I mean, I think there are some aspects of how swaps are transacted which may not yet be fully in the knowledge of potential claimants, and that if there is some kind of deceit or concealment as to those costs and charges, then that might be where some kinds of arguments in relation to limitation on claims might go. Knowing what I do about swaps and about how they're charged and all the different components and the manner in which margin liabilities are preserved and so on, I would be surprised if there is a strong argument to reopen litigation in respect of sales that took place in 07 and 08. But I don't think I can say more than that.
Thank you, Simon. Thank you very much. We're going to go to Nigel, then to Hock, then I'm going to go back to where we got to on the crowd funding page. Nigel, thank you, Nigel.
Hi, everybody. Duty of candour. Who owes the duty? Is it the FCA or is it the executives that make the decision to refuse to disclose information, such as Rafi and Alder? Or are they both, do they both independently have a duty of candour?
The duty is owed by the defendant, so it's owed by the entity itself, the FCA. The directors, the executive individuals of the FCA, have a duty to ensure that the FCA complies with its duties, but that is not in itself an independent duty of candour. The FCA will, the executives of the FCA will owe duties to the FCA. And one of those will be along the lines of ensuring that the FCA itself complies with its duties in litigation. I don't expect, I mean, it would have to be pretty extraordinary circumstances, I think, to pull executives of the FCA into the fight about whether or not that duty has been discharged. And to be honest, I'm not sure it would move it along at all. Ultimately, we need to show the court, the organisation, has not given us what it needs. And if the court's satisfied by that, then the court will order that it be disclosed, and ultimately the executives will have to ensure that the FCA complies with that order.
So, as usual, the individuals themselves are in no peril whatsoever.
Yes, save if there's some kind of dishonesty, gross misconduct, something like that. Yeah. We don't have any evidence to suggest that that's right, and you'd need pretty firm evidence to make allegations of that sort.
Effectively, no accountability then. I would say.
Well, I mean, there's a difficulty with accountability, but ultimately, if we get an order from the court, it doesn't really matter because the FCA will have to comply, and then ultimately accountability will rest in what the FCA produce. But yes, there is an inherent abstraction between the individuals who have to perform these activities and the legal person, so the entity that's ultimately responsible for them.
Nigel, thank you.
Yeah, thank you very much.
We're going to go to Hock, then we're going to go to Mark. Now, for those of you that don't know Hock has been a truly wonderful volunteer for TTF, along with one of his colleagues in the Isle of Man, on a completely unrelated matter. But the common denominator is the FCA doing naughty things, I would say. Hock, please share your thought. Thank you.
Good evening, everyone. And first of all, can I just send my commiserations to all the victims in this horrible situation? The injustices must be unbearable. I would just mention to the legal team that I've shared with you emails offline regarding Brooks and Barnard, the words of Lord Devlin back in the 1960s regarding exemplary damages and the duties, effectively, of public servants, which the FCA are. The first category that he quoted for giving rise to exemplary damages, which in common parlance to the ordinary man is punitive damages, which is vanishingly rare in English law. It's like a unicorn. It never happens. Well, almost never happens. And the first category is oppressive, arbitrary, and unconstitutional action by servants of the government. In the case of the government, it is different. For the servants of the government are also servants of the people, and the use of their power must always be subordinate to their duty of service. And that is almost also underwritten by the Nolan principles. So I think that's an area to consider because that could raise the ante. And we did use that in Damien's wife's claim in the Isle of Man against the Isle of Man Department of Health and Social Care, who are also playing tricksy non-disclosure games where they consistently failed to comply with standard disclosure, including late, very late, and post-hearing disclosure, and adducing documents which appear to be concocted by the department, i.e. Forged documents. And following all of that, we actually got an order for, or Damien and his Roz's QC, KC now, managed to obtain an order, an award of both aggravated but also exemplary damages in that case. So that may be a tactic just to up the pressure on the FCA. And that's all I wanted to say as my thought for this evening. Thank you.
Well, thank you very much indeed for sharing your thoughts. I put into the chat, folks, the matter that Hock was just referring to, a remarkable case where the wife of somebody that's a good friend of Hock's stood up against an oppressive authority, stood her ground and won. And it's a fantastic example of what can happen if you stand your ground and refuse to be bullied into submission. Thanks, Hock. Thank you very much, not only for sharing your thoughts just now, but for the amazing work that yourself and Damien are doing behind the scenes. Thank you. Mr. Mark Bishop, no relative to Simon. I know we always say that, bit of a joke. Mark.
Okay, thank you, Andy. I'd like to firstly congratulate both, the APPG team and of course the Housefeldt team on having achieved so much here. I think, I've read the reply to the FCA's defence, and I stress I'm not a lawyer, but when I saw it, I emailed back, I think Ned, and said, I would have loved to have been a fly on the wall in the offices of the executive suite at the FCA or in the General Counsel's division when that thing came through, because I bet there were some uncomfortable moments, maybe somebody kind of punching a wall and damaging, their hand or something. And one of the reasons why I think it's so significant, actually, it's very significant for people who aren't RHP victims as much as those who are, because if this succeeds, effectively it will take away one of the FCA's superpowers. I think one of the superpowers it thinks it enjoys at the moment is that consumers, small businesses can't really touch it. You can't sue it unless you can prove human rights breach or bad faith, and nobody succeeded. There's a complaints commissioner, but that person is basically a servant of the city, and even their recommendations are only advisory. The FCA doesn't have to pay out any redress unless it wants to, and it doesn't want to. It's never paid out material amounts of redress for regulatory failure. And you don't have the rights that the industry does. If a firm in the industry doesn't like an intention by the FCA to enforce against it, it can go to the Regulatory Decisions Committee, it can go to the upper tribunal. As a consumer, you don't have those options to pursue the FCA for not enforcing. The only thing you've got is judicial review. And for a judicial review to even happen, you've got to know that a decision was made. And quite often the decision to do nothing is made at a low level and you don't get to know about it because they say they can't comment. It's only here where there's been a public announcement that there is a defined decision and therefore a fixed period of time to challenge it, and that challenge has happened. So I think it's really important for everybody. I also think it's important because I have an instinct here, a feeling. I stress I'm not a lawyer, but I have been a journalist, and the journalist in me thinks there's an interesting angle here, which is that one of the big defences of the FCA is effectively that the banks back in 2011, 2012 thought they were getting a full and final settlement. They thought that if they paid up under the restricted redress scheme, there would be no imposition on them of some other redress scheme or any other sanction down the line. That is FCA's position. But I have read the announcement that was made, or the copy of the agreement that was put in the public domain at the time, and to me as a non-lawyer, it doesn't look as though that was the case. It basically said we've entered into this agreement, but we, the FCA or FSA as it was in those days, we have not in any way compromised any of our rights, our statutory powers. And I do feel that there's a contradiction between those two positions. And the only way that you can kind of square that circle is that the agreement that was published is not the full extent of the true agreement. I'm not suggesting there's necessarily another agreement in writing that says, don't worry, we're not going to come after you. Maybe there was an exchange of emails, or maybe it was just a quiet word, in a corridor somewhere. But clearly it does appear that the banks have come away with an impression which is different than what the FCA or FSA appears publicly to have signed up to. And it feels to me that if the regulator has proven effectively to have lied to the public and to have done some secret deal that wasn't fessing up to, that could have ramifications, not just for the organisation, but for the individuals.
Mark, thank you very much indeed. Ned or Simon, do either of you want to kind of come in on that and reflect on what Mark just set out?
Just one comment on that. As you were referring to that, Mark, I was just trying to get hold of the judgment, so the permission judgment, because I think rather than it being a sort of hidden aspect of the agreement, it's something slightly less nefarious in that it's an argument as to how the agreement that you have seen should be interpreted. And there's a passage in the permission judgment, which is actually it's a quite a short document, and it makes for a good read if you've got the time. But there is a passage in that judgment where he explains that interpretation argument, and there's a debate to be had about that. I think the FCA has the right to make that argument, as i.e. to say that we thought when we were entering into this contract, it meant that we had agreed not to pursue the bank in respect of this issue so far as regulatory intervention is concerned any further. I don't think it's a particularly good argument because of what the contract actually says. In order for that argument to succeed, you have to read an additional word into the contract that's simply not there. There's an additional point which we've spoken about before, and that's that does the FCA even have the right or the power to contract out of its obligations in that way, or is it ultra vires for them to do so? Some of that got ventilated at the permission hearing. We expect it will be ventilated in more detail at a full trial, but I don't think it will go outside the scope of that debate, i.e. what does the contract mean, number one, and number two, if it means what the FCA contends it means, did they even have the ability to do that?
It's okay. I mean, I say, I stress always I'm not a lawyer, but there was a great passage in your reply where you basically say, for the agreement to mean what the FCA is now contending that it meant, it would not have been written this way. It would have instead have been written this other way, and you show how it would have been written. And as a layperson, I kind of agreed with that. It wasn't written in the way that would have the meaning that they intended. And this is clearly a document that's been heavily lawyered by very expensive lawyers on both sides. You know, how many counsels are there in the FCA's General Counsel Division? It's an expensive unit. That, you know, it can't be, you know, lax drafting or anything like that. It, you know, an agreement means what it says, I think. And what that said was that the FCA was not giving away or, you know, waiving any of its rights. And if it had said that it was waiving any of its rights, then perhaps at that time there would have been a judicial review, and the judicial review would have succeeded. But it didn't say that, therefore there wasn't such a review. So how can it retrospectively then try and effectively rewrite the agreement to pretend it means something that it didn't? I mean, I'm not a lawyer, but it does seem to me that, you know, that probably the strongest argument that they have in a way is this argument, and I think it's a really weak argument.
Thanks, Mark. Seems like the FCA, in my very plain English, are trying to squirm the way out, of it. We're going to go to general Q&A. Please feel free to chip in with comments and questions. Please be as succinct as possible so we can get around as many people as we can. Hubert, did you want to come in? Yes, you did, sir. Go for it. Thank you.
Just a quick one. Am I on? Okay.
Yes.
Yeah, just a quick one. Thanks to Heather Buchanan. It's the first time I've noticed her on the screen. Heather and Leslie Sheriff did a case study of mine some years ago and presented it to Westminster. And my MP addressed the subject in Westminster of Danske Bank and their carry on with me. In the case study that Heather and Leslie did, they were very, very sharp on making clear that Danske Bank had, in effect, asset stripped me. Now, that was pretty clear, and I would have thought at that time that some of Danske Bank's legal people would have been challenging me and saying, prove it. And I don't feel that comfortable in the present group of legals, because they're obviously way ahead of me in terms of how they're producing and presenting the APPG case. I, through Heather and through Leslie, they did a super job, and I got absolutely nowhere. The BBRS, an absolute total waste of time, waste of space, waste of money, and it fails me. I can only admire those gentlemen that have been talking this evening with the knowledge that they've got, that is able to take on these sorts of cases. And I think you're right, Andy. I do think that they need the financial support that people are being asked for. I unfortunately am in a bracket now where I'm well over my pension age, and I'm well over being able to support myself. And Danske Bank were culpable in all of that. And when I look at what I lost between 4 and 5 million, and I look at that and I think I would give that a fair shot to the TTF, because so far I haven't heard anyone speak on behalf of the people who have been screwed by the banks, and I haven't heard very much in terms of the legal cases that have been put forward and that are presently being argued. And I must admire those gentlemen that are doing that. Please, please keep it going. You're to be admired. And thanks, Andy, for keeping this channel open. It's absolutely important, vital to us, and we do need it. Thank you very much. Thanks, Heather. That's me.
Thank you.
You're welcome.
Thanks for your very supportive comments all round here, but much appreciated. We're going to hear from Lisa King. Please share your thoughts, Lisa. You're taking yourself off mute, I can see. Lisa, over to you. Thank you.
Thank you, Andy. Ahead of today's meeting, I've written up my thoughts on the FCA. I've written them up so I can read them out to you, because when I discuss the appalling way my late husband was treated, I get very emotional, and sometimes I can't articulate it well. So I'm going to read out something I prepared earlier.
You take your time, Lisa, and you do that. Go for it. Go for it, girl. Thank you.
Disclosure, deceit, and miscarriages of justice go hand in hand. I, like many of the folks here tonight, have listened to contributors to TTF meetings demonstrate how the morally delinquent FCA lie like we breathe. The recent disclosures of the FCA operating an intercept and divert policy on emails, and the watering down of the John Swift KC review into the mis-selling of IRHP to protect the banks, whilst denying many victims redress, is a charge sheet of poor behaviour where an ecosystem of dishonesty flourishes and the truth withers away. And yet those responsible remain in positions of prominence long after the damage they have inflicted became clear to see. The FCA, the Complaints Commission, the ICO and the SRA exist to protect consumers. Instead, their undiluted support for their paymasters is their only priority. The result, facing all victims, is a toxic erosion of the sense of honesty and integrity that once underpinned financial institutions. The canker running through the veins of the FCA needs eradicating fast. We are all victims twice over, a victim of the crime and a victim of the FCA malevolent behaviour. No one should be rewarded for failure, yet those responsible for causing such egregious harm to my late husband, Peter, have been able to rise up the greasy pole of promotion as a reward for their dishonesty. I only hope that Peter can rest in peace, knowing that I did everything I possibly could. That I did everything I possibly could to be his voice and make sure the truth is told. Thank you, Andy.
Lisa, thank you. Lisa, bless you. Can we please show our support for Lisa? Lisa, are either of the boys home tonight?
Yeah, one of them's here.
Lisa, thank you very much. I don't mind saying this. Maybe this is too embarrassing to say, but I'm going to say it anyway. I've kind of learned in recent years to very frequently disconnect my brain and just speak from the heart. Something happened about 2 years ago, which I'll never, ever forget. Lisa, I hope you don't mind me embarrassing you when I embarrass myself. Lisa told me on a Zoom conversation what the bank had done to her husband and how the FCA tried to make out that it was a one-off case and that the FCA don't deal with individual cases. It turns out there were 30,000 other people in a similar situation. I'm not making the number up, 30,000. And Lisa explained to me about a recording of a conversation that she heard and she relayed to me. I'm not going to say what that conversation was, but Lisa relayed that conversation to me, and Lisa started crying, as you would. If you knew what she was talking about, you'd understand why Lisa started crying. And I started crying. I think it was quite weird. For about 2 or 3 minutes, there was a really weird Zoom conversation going on. At one end of the Zoom conversation, there was Lisa in tears. And on the other end of the Zoom conversation was me in tears. And whilst I admit that at the time, it was a really horrible experience to feel Lisa's pain the way that I did, I can tell you something, Lisa, from the bottom of my heart, that moment of soul-to-soul interaction with you, understanding the pain that yourself and Peter went through, understanding the brilliant job that Paul Carlier did to try to defend your interests, understanding the, frankly, grotesque lack of humanity shown by the bank and by the FCA, is going to stay with me forever. It's going to stay with me forever, Lisa, and you will never understand or know how inspiring and how motivating your participation at our events is. I've spent quite a bit of time recently with people who suffered at the hands of banking misconduct, people who run businesses. There have been suicides, there's been well-being shattered for many, many, many people. That is what we're fighting for, folks. We're fighting for decency and we're fighting to stand up against bullies. And there's no other way of describing it. There's no other way of describing it. I remember being sat in that courtroom in June, towards the back of the courtroom, thinking, how on earth can the barrister acting for the FCA sleep at night? How can they do it? How can they do it? I'm going to, before we go to our next speaker, I'm just going to share my screen once again because some of you may know that TTF put some time and effort into a document that we published last year. Frankly, we're really proud of this. You would not believe the amount of work that went into it. Faces of Financial Crime. It's many, many pages analysing case studies and trying to understand the human cost and suffering when somebody is shafted, whether they're shafted by a dodgy scammer or a well-suited banker. It's all the same thing. There are many case studies in here. There are 22, including Mike Lloyd's and many, many others. I'll put a link to it in the chat. please do take a moment to look at it and read it if you can. Lisa, thank you. I'm going to go back to Ned and Simon to invite them to comment further if they wish in relation to the legal proceedings, and then we'll open it up again. Thank you. Ned, Simon, please do come in. Thank you.
Nothing further from me on the legal proceedings. So if there's any more questions, really happy to take them.
Thank you very much indeed. Any other comments and thoughts, folks? Please wave your hand at me either digitally or otherwise if you'd like to come in with a comment or a question. Preferably somebody who hasn't yet had a chance to share their thoughts, and then we'll go to others who have. Okay, I think we're good. Mr. Mike McGrath, please, I know you can't talk about your particular case. That would be inappropriate to do so given where you are with proceedings. So without talking about your particular case, talking very, very generally, Mike, what's your take on this whole JR business and the FCA and the banks? Thank you.
Well, obviously listening to Lisa, I can totally understand the situation that a husband and a family were placed in, because there's nowhere to go. And believe me, I've been to court, financial ombudsman, BBRS, and hopefully I will have a solution which may assist other people. But the one question I want to ask is, how the hell have these people got away with what they've done?
Wow.
How the hell have they got into a position where somebody in a bank can affect not just you, your livelihood, everything you've built up? How can somebody make a decision, then the people above it cover it up, and then you go to some form of kind of resolution service that's been put in place not to help resolve the situation, but to cover up what's been done? How can that situation exist?
I'll tell you what I'm going to do. I'm going to put him on the spot. Mark Bishop, you and I have many conversations about the kind of the systemic structural flaws in the system that that effectively answer the question that Mike just asked about how come there's such a lack of transparency and accountability that stuff like this can actually happen. Mark, I think you're still with us. If you are, please do respond to that. If not, I will. I think Mark may have had to go. I'll answer it, Mike. I think we have a situation, Mike, where there is a complete lack of sufficient accountability. People are able to hide in the shadows. You know the phrase we use quite a bit, sunlight is the best disinfectant. There is a complete lack of accountability and scrutiny. Many of you will know that TTF spent quite a bit of time this year and last year in relation to the Financial Services and Markets Bill. And there are three things that TTF wants from a kind of policy point of view. One is the removal of the FCA's immunity from civil liability. We think it's wrong that consumers cannot challenge the FCA in court. We think that is totally wrong. We think that needs to change. We believe it's right that the industry cannot routinely challenge the FCA in court. If it could, it would be there all the time. It couldn't get on with its job. But we think it's a fundamental error that consumers are included in the FCA's immunity against civil liability. The second thing we want to see from a policy point of view is a proper duty of care where there is a private right to action. Again, that would empower the consumer and help to fix the asymmetry of power and information that overrides this landscape. And the third thing we want to see is what we call a financial regulators supervisory council, which is basically an evolution of the ideas that have become established in the Australian market in recent years, something that basically properly scrutinises the work of the regulator. We don't think the Treasury Committee's got the bandwidth to do it. We don't think the Financial Services Consumer Panel is sufficiently independent or robust to do it. And the net result is we have a regulator that frankly runs amok and behaves as if it can get away with anything it wants to. But those would be my comments. I see we have Scott and Norma Henderson. I think we're going to go to Ned in just a moment. I think Ned just took himself off mute there. Well, Ned, we'll go to you. But after that, I'd love to hear from Norma and or Scott Henderson if they'd like to chip in with their comments about what we discussed today. I can also see Rochelle raising her hand. Rochelle, why don't you come in now? Then we'll go to Ned, then we'll go to Norma and or Scott. Thanks, Rochelle. Thank you. Please start off by introducing yourself. Thank you.
My name is Rochelle Schonwald. I'm a victim of the interest rate hedging product. But first and foremost, I'd like to just say to Lisa, what a brave person you are and how I admire each and every one of you who have spoken this evening. I am not as erudite as any of you here, but very, very briefly, I was widowed at 48, and to boost my income, I started to buy property and rent it out. Was doing quite nicely and had not a huge portfolio by any stretch of the imagination. It wasn't a business that was incorporated, but I had banked with Midlands / HSBC for, at that point, probably well over 40 years. My manager called me and said he could see that I was banking quite nicely, and would I like to come in for a chat? That was the worst day of my life. I got involved in the swap by him saying to me, would you like to fix your rate like a mortgage so that you know exactly what's coming in and what's going out? Of course, I said, absolutely. And that was the beginning of the end for me. I'm now 74 years of age. I'm about to have to sell my house. I've got no policies. I've got no income, and I have no pension. I've spent many years crying, beating my breast, worrying, how was I going to survive? My MP, Mike Freer, actually spoke on my behalf in Parliament. Since then, nothing has happened. I've written, I've got no response. I had a meeting with my lawyer at HSBC headquarters in Canary Wharf, where two men, my lawyer at that time was a woman, where two bankers sat opposite and told me in no uncertain manner, there, little lady, don't you worry, you've got it all wrong. My lawyer was completely aghast. I was then in tears. He said, look how emotional you get over this. Yes, this is my life that you're ruining. Nothing's happened since. I've written everywhere to everybody and got nowhere. I'm still fighting, I'm still trying, but good luck to all of you. You're all terrific. I'm not in the multi-million-pound bracket. I have no idea how I got myself into this. Santander said they would take me on and get rid of the swap. HSB would not release me. They told Santander I had not run my account properly. Well, of course I hadn't run my account properly. I had umpteen emails a day demanding money. I had to sell everything to keep those damn people going. £1,000 in the hand, I was told. Each time they sold a product, they got £1,000 in the hand. That's all really I wanted to say, but thank you all very much for listening, and thank you for being there. And I've spent half the evening crying. I'll probably spend the next half of the evening crying yet again. And so unsophisticated, not sophisticated, totally unsophisticated. Yeah. And there you have it very briefly. Please carry on the evening.
Rochelle, thank you so much. Thank you very, very much for coming forward in the way that you have. Rochelle, would you mind if I connected you to Lisa by email? Could I please do that?
Absolutely.
Thank
no
you.
problem.
We've got to know Lisa very well in recent years, and I think you could be good company for each other, if for want of a better phrase, you know. Isn't that amazing? I've heard so many people talk about that they can remember the specific moment when the bank contacted them and put an idea across in such a way that it would sound, they'd have to be daft not to say, yes, of course, I prefer to fix my rate and know where my incomes and outgoings are. Of course you would. And then that's the slippery slope that you end up having your house repossessed or whatever it might be. Thank you very much indeed. Norma and Scott, your case is truly fascinating. If either of you want to come in and talk about why you're hopeful that this JR is going to succeed, that would be good. You don't have to. I don't want to put you on the spot, but Norma, Scott, if you want to speak, please do so now, and then we'll start bringing proceedings to the close. Thank you.
Hi, Andy. Well, thank you very much for the opportunity to speak here. Yeah, IRHP, like probably everybody else in this call tonight, all had a interest rate hedging swap included in our loans, which were taken out in 1997. Again, like Rochelle said, it was mortgage style. At the time, conservators were just a way to probably lose Labour coming in, historically high interest rates. We wanted to know exactly what we're going to be paying every month. And as everyone else has, the interest rates obviously went down instead of up. And yeah, the rest is history, as we say. We have just learnt in this last month that the FCA had direct involvement with our case between 2012 and 2016, which we never knew about. And one of these things is, you know, why weren't they asking these questions of documentations direct from the bank? You know, we have documentation from RBS that states specifically there is no interest rate hedging product in the within the loan, but every other expert we've spoken to said there's no product that can have a fixed rate loan without an interest rate hedging product or derivative within it. So yeah, hats off to these people that are Ned and Simon, etc., lawyers taking FCA to court. They definitely need to be held accountable. There's no question about it. They hide behind immunity as think they're untouchable and whatever they do and say doesn't matter, you know. Well, you can see here tonight how emotional and how it hurts everybody's well-being, their mental states, etc. Andy, thank you very much, and obviously all the best, and we're looking really forward to hopefully April next year when something comes.
Scott, thank you. Great to have you with us, and Norma as well. Scott and Norma Henderson, thank you very much. In a moment, I'm going to pass to Ned for any final comments, be they legal or general, from Ned Beale. Then we'll bring proceedings to a close. But remember, folks, the vehicle is the JR. The JR, the vehicle, can't run without the fuel. Please make that emotionally based decision to do something to support it. Choose whatever the number is that's right for you. It's going to vary from person to person, but do what you can, please, to help this. There's no doubt about it in my mind, folks, that the victory of this JR would send shockwaves that will have benefits in so many of the campaigns that we are involved with. Mr. Ned Beale, your final comments before I then formally wrap up the session. Thanks, Ned.
I'll give final comment for me and Simon, who I think internet has just collapsed. But Andy, thanks so much for organising this. It's really, really useful and important. And thanks also for the APPG, because there is a great degree of this cost risk, this reputational risk. The FCA instructed the biggest law firm in the world, Magic Circle Barristers. And so there was a lot of kind of holding our nerve, especially till we got to permission and cost capping, which I know Heather and Jackie has kind of kept everybody on track to do it. But most of all, thank you to everybody here, because you know the support means lots and lots. And I know over the years there's been lots of expertise, and we kind of carefully consider everything people throw into the mix and see how we can best use it. So thank you all, and we will keep fighting as hard as we can.
Ned, thank you. Well done, APG. Well done, APPG. Well done, Ned. Well done, Simon. Well done, everybody. Lisa, Rochelle. We won't forget the way that you've spoken to us tonight, and everybody else as well. Let's commit to doing two things. Support the JR in whatever way is right for you. It's going to vary from person to person, but perhaps even more importantly, let's continue to support each other. Some of you are going through particularly tough times at the minute, and we can be there for each other. That's really what it's all about. Let's bring the session to a close by giving ourselves a bit of encouragement to do that. Thank you very much indeed, folks. Thank you. We'll update as and when Ned and Simon suggest we should. Maybe in another month or so, we'll have a catch up. Thank you all very much indeed. Good night. Cheers, Ned. Thanks, Heather, Jackie. Thanks all.